Good evening, class. So tonight we are going to learn about deeds. And for those that have the book, we're going to be in chapter 6 tonight. And what I'm going to do is start by talking about the different types of deeds that are out there, basically the general types of deeds that are out there. There are also other assortments of deeds that we'll mention. But there's three major types of deeds, I guess is the way you can classify it. So tonight we're going to learn about deeds and the transfer of title. And this is all part of your title segment. So chapter 6, away we go. We're going to jump right over onto, the book that I have is page 6-2, where it actually starts to talk about the types of deeds, the three major types of deeds. And so the first major type of deed, I guess we can talk about, is the general warranty deed. This provides the buyer or the grantee with the highest form of protection from the seller. And basically in these types of deeds, there are protections that the seller is going to offer to the buyer, and they are general protections and the best type of protections, because the difference here is when the seller says that they're going to offer a warranty, or as we say legally, a covenant, right? It's like a promise. The seller is going to extend this promise to the buyer, and it's going to go all throughout time, okay? Throughout the beginning of time. So the seller is going to say to the buyer, or the grantor, right, is going to say to the buyer, I'm going to give you certain types of protections against future claims. And so the first one is the covenant of sizing. And the covenant of sizing, basically in your book, is going to say that the grantor warrants that they hold title, okay? And they have the ability to convey that title, or grant that title, give that title to the buyer, okay? Second type of covenant is the covenant of the right to convey, which basically means that the seller warrants that they have the right to give a free title to the buyer, or a clear title to the buyer. The third covenant or promise that the seller is going to make to the buyer is the covenant against encumbrances. So basically what we learned we're going to learn in other segments is an encumbrance is like a cloud, or like a blemish on title. And so the seller is going to say to the buyer, hey, listen, buyer, I'm going to give you clean title, and the only blemishes you may have on title are things that I'm going to disclose to you. So if it's not listed in title somewhere, then it's clear. Okay, so no encumbrances. And then there's the covenant of quiet enjoyment. And so basically what the seller says to, or the grantor says to the buyer, is that there are no that the grantor warrants that the grantee shall enjoy quiet enjoyment and will not be disturbed by any third party out there. Okay, that is the covenant of quiet enjoyment. The next covenant is the covenant of further assurance. And in the covenant of further assurance, the seller says or warrants that they will take any future action necessary to correct any problems or to protect the buyer. All right, someone should attack title. And then there's the covenant of warranty, which is the promise of warranty, I guess. And the seller says, or the grantor says, that they will defend title to the grantee against the claims of anyone, and including claims arising from the time prior to the grantor's ownership. So all throughout time, they are going to come in and they're going to defend title against anybody out there. So that is the best type of a deed that a buyer can get, is a general warranty deed. We don't see those in Massachusetts. We see the third one on our list here. But the next one down the line is a special warranty deed. And with the special warranty deed, basically the grantor guarantees the buyer or the grantee against any defects or claims which arose during the grantor's period of ownership. So the difference between a general warranty deed and the special warranty deed is the duration of time of the promises. The promises that the seller extends to the buyer are the same in both deeds, but the period of time is shorter. So with the general warranty deed, it's all throughout time, even for owners prior to the present seller. So all owners throughout time. Whereas the special warranty deed is just for this seller. It's just for this period of time. So if you think of it this way, the expansion of time is the general warranty deed, the special warranty deed, right? It's just for the period of time that the seller owns the property, and that's it. Nothing else in the chain of title or in the history of title will be defended against. Hopefully that makes it clear. And in Massachusetts, what is given by a seller or a grantor is a quitclaim deed. And for purposes of learning, basically the book's going to say that you can classify the quitclaim deed as a special warranty deed, which is what we just went over. But for me, it conveys whatever interest the grantor has in the property, but makes no warranties or guarantees to what they include. Okay, so basically for me, and the way that it operates in Massachusetts, the buyer gets what they get and they don't get upset. That's what my kids always say, right? So the buyer is going to do a title exam prior to the closing, and that's what they're going to get. They're going to rely on that title exam that they conducted. Okay, so those are the three major types of warrant deeds that are used in general. Other types of deeds the book will go into is there's a deed in trust. So that basically is when a grantor or a trustor, as it says here in the definition, transfers title into a trust. Okay, so it goes from an individual probably into a trust. That is a deed in or deed into trust. A trustee's deed, on the other hand, is when the property sits in a trust and the trustee signs the deed out of trust. So it goes out of trust. Okay, one goes in, the other one goes out. A bargain and sale deed contains no express warranties but implies that the grantor holds title in possession, like a foreclosure deed or a tax sale. A judicial deed, right, just look at the term, means probably a court or a judge, right? Used by a court appointed official and are known by the activity that the court has taken to carry out. No warranties, okay? An executor's deed, probably in Massachusetts now called a personal representative's deed, but it's just like the term says. It's coming out of an estate, right? An executor usually handles an estate. So an executor of an estate will sell an estate's property at the direction of the court. A tax deed, look at the term again, right? It's a conveyed property taken by the government for non-payment of taxes. And then there's the sheriff's deed. And this is used usually in a foreclosed property situation. Okay? All right, so those are the general types of deeds that are out there. Now, what do you need for elements? What do you need to have a deed? Well, for that, we're going to go right over to my sample deed that I've created, that I usually give out to my classes. And so as far as the elements of what a deed contains, first you're going to have the name of the seller. And in our sample here, it's going to be Shifty Seller. And we're going to identify, and usually we'll give an address as to where Shifty Seller lives, just to identify who Shifty Seller is. I use the word shifty because that used to be a nickname of a client of mine. Yeah, and he was shifty. The next thing you're going to see probably is the grantee, right? That's going to stick out. And that's Boris and Natasha Beyer, okay? And here, one of our other segments, we talked about concurrent tenancies. If these folks are married, then here is where you would state husband and wife tenants by the entirety, okay? So the grantees will be there along with their tenancy stated. And then you're always going to have, just like any other contract, because this is a contract, folks, consideration. And so the consideration is going to be stated here. How much is for it? $255,000 is our consideration on this deed. Okay, something of value, as I mentioned before in other segments, especially with the elements of contract, something of value has to be stated here. It could be $255,000. It could be $1. It could be love and affection. That's something of value as well, too. It doesn't necessarily have to be monetary, right? Okay. The granting clause, which sometimes we just state grant or grants. And that's going to say, that's actually going to be the action term, right? We're going to grant, or the seller is going to grant title to the grantee or to the buyer, right? And the tenancy is also going to be stated. The habendum clause is to have and to hold. It follows the granting clause, all right? And some deeds will have it, but basically what you're going to see is here, it says with quitclaim covenants, basically is going to state how they're going to hold title, to have and to hold. There's your habendum clause. Just a couple of words, right? The next you're going to have is the legal description. Excuse me, the legal description. And in Massachusetts, basically, there are two types of legal description. In this chapter, we will see a third, which is the government survey. That's used out west. But in Massachusetts, it's either going to be the reference to a plan, right, that's been recorded at the Registry of Deeds, or it's going to be a description of the property. So one's a reference to a plan, right? And that's a description. It's also called lot and block in your book. The plan would be the lot and block, but it's actually a reference to a lot in a plan. It's the same thing, okay? Or a meets and bounds description, which is going to be, you're going to see a direction in the meets and bounds, right, northwesterly, and you're going to see a distance in the meets and bounds, which is 43 feet. So basically that's telling somebody who's walking the perimeter of the lot to go northwesterly 43 feet. And that's what they do. What our engineers do with tape measures. They walk the lot line. So with a meets and bounds description, it's an explanation of the perimeter of the parcel of land. So Massachusetts, those are your two big descriptions on a deed. It's either going to be reference to a plan, which is a book and a page, or it's going to be a meets and bounds description, which is describing the exterior or the perimeter of the lot line. It's going to tell a person where to walk and what distance to walk. What else is on a deed? Well, let's see. The book does mention government survey, which we will talk about, but please read that section because it's not something that's common to Massachusetts, but you do have to know the terminology associated with it, okay? That's another description of or another way that you can describe property. All right, and what you're going to see in the deed here, although the book doesn't really mention it, is square footage. That's not really a component that's necessary, but you'll see it a lot. And a title reference. Now, a title reference is not something that you're going to see here that's recording the deed. Yeah, so you're not going to see here in the book, it's not going to mention it as being a requirement to have the deed, but this is a way that we allow our title examiners to chain title back, okay? So what this is, it's going to be on every deed for the most part, and it's a reference to the prior deed. So we have a deed here, and what this is basically saying is to see the title from our seller or into our seller, who is shifty seller, okay? Go back to this deed back in 2013, right? Our deed is in 2018, for example's sake. But it's telling you to go back to 2013 and see a previous deed. And what that allows our title examiners to do is to jump from deed to deed to deed. In essence, jump from owner to owner to owner to chain title back amongst the owners. Okay? So we call it a title reference. It's going to be contained in your deed. But as far as your components, back to your book, back on 6-6, it's going to say we need the signature of just the grantor, of just the seller here. Okay? You don't need the signature of the buyer on a deed. It's basically one of the only contracts that I've seen where only one party signs, and that's the seller. Okay? So you need the seller's signature. Next, you need delivery and acceptance. Okay? And for delivery and acceptance, so it's got to be delivered by the seller to the buyer. All right. And so what it says in the book here, acceptance can be actual or implied. A deed may be delivered directly to the grantee, to the buyer, or it may be delivered to a representative of the grantee, which would be the attorney. Okay. So delivery has to happen and it has to be accepted by the buyer. And then you've got an acknowledgement. And so basically when it comes down to a notary, as a notary, which I am, when we take a deed, basically we say to our seller, So you're signing everything freely and voluntarily. And what we're trying to confirm here is that there is no duress when a deed is being signed. So you have to have the acknowledgement of the seller in order to indicate that there's no duress. Now, you don't need a notary clause on a deed. A deed is valid just with this signature alone and no notary clause. But in order for a deed to be recorded at the registry of deeds, you have to have it notarized. And so one thing you have to take into account, so they might ask you this on the test, is a deed that's not notarized valid? And the answer is yes, it is valid. It's valid as soon as the seller signs it. It doesn't need to be notarized. But in order for a deed to be recorded at the registry of deeds, it must be notarized. There must be an acknowledgement there. And a deed that's been recorded at the registry of deeds has priority over a deed that's not recorded at the registry of deeds. So it's important then to have a notary there, but it does not make the deed void if it's not there. All right, they will ask you that question. So the book does go in and talk about recording the deed. All right, and then the next section will talk about the Tauren system. So I'll explain that a little bit here. Okay, and so what's the Tauren system? All right, so off we go from deeds to the next section in the book to 6-7. 6-7, it talks about our Tauren system. So it says, Massachusetts has developed a land court system to settle disputes between previous owners, between neighbors, and it's called the Tauren system. When a property is, so the way I usually explain it to my class is this. When you go into the registry of deeds, you can go to one of two desks, right? There'll be people sitting at two desks. One desk will be our recorded land section, which basically everybody, the majority of people go to. And that indicates that the property's never been involved in a conflict or there's never been any type of a determination on the property by the land court. So it's a court in Massachusetts. Now, if for some reason that property has been litigated, and there's been something going on with lot lines, or there's been some type of a thing that needs to be quieted, as they say, quiet title, then a piece of property will go through the land court. And if that's the case, then a certificate of title will be issued by the land court. And that land is called registered. So in the registry of deeds, you have a recorded land desk, which everybody can go to, and then you have a registered land desk. That is land court land that's been litigated. And so when land's been litigated, you have the court will issue what we call a certificate of title for that land. So when a dispute arises over title or lot lines, the land court makes a final determination. No prior claims can be raised, and the land is referred to as registered land. Okay? So that is what we mean by registered land. And then we go on to talk about title searches. And so what I will encourage the class to do at this point is read on in the section. We will certainly cover this in class as well. But this concludes our segment on deeds and basically recording deeds. All right, I hope you enjoyed that. And I look forward to talking to you in the next section.